This meeting is being recorded.
Hi, Kate Floss from the Ministry of Deconfusion, and I'm Minister Kate Floss, coming here to deconfuse the public. There's been a psychological waterboarding by Parliament and courts and various United Nations entity, an absolute waterboarding of law onto the people of New Zealand, and the people of New Zealand have become extremely confused and not able to, feeling that their arms are being taken away from them and they're not able to protect themselves under the law. By using the law is supposed to protect you, but law can also be used as a weapon. And in my opinion, currently, Parliament is using law as a weapon against the people of New Zealand. This is also occurring against the people of Australia, Scotland, Ireland, England, and what they're doing is bringing down the United Kingdom and bringing down the Commonwealth and placing us all under United Nations law. And we've all got to stand together and we've got to fight back. The only way we're going to do that is to learn, because if you go back 400 years ago, they had to learn how to fight against these entities, the Roman Catholic Church, the fight against the Jewish synagogue or whatever they call them, and the Islamic religions, all those religions that were trying to put the Protestant people under their laws, and now they're currently trying to put us under the Noah child laws. But that's another story. What we've got to do is learn. Now, just quickly tell you that at exactly 7:30, which is 10 minutes from now, I'm going to be having a meeting. Maybe it might be just a wee bit later than that. I'm going to be having a meeting about the Justice Committee. Now, I've entered a case using our 1688 Will and Mary to the Justice Committee, and we get 5 minutes for speaking. This is just going to show you that video is going to show you how to go to the bills that are in Parliament, how to use your 1688 law, and how to make a submission. So I'm going to be showing that in the next video. I'm getting tired of all these videos. But for this one here, what I wanted to show you is the Cabinet Manual. Now, Scotland, Ireland, and England have all got this 1688 in their Cabinet Manual, but I've tried to find Australia's, but I can't find it, but I'm still searching. I'm a bit pushed for time, and we've got to get this stuff out fast to you, because they are moving at lightning speed against us. Lightning speed against us. So we've got to move at lightning speed against them. We need to be having these videos almost every day. You've got to listen. Pop it in the car and listen to it in the car. Listen to it while you're doing the ironing. Listen to it while you're washing the dishes. These are all the things that I have to do. I have to listen. I have to learn. I have to study. And all you've got to do in this war of information is listen to videos and collect up your information to get your armor. You need to arm yourselves with the law. Don't arm yourself with guns. Arm yourself with the law. And let me tell you something, all wars began with a declaration, and all wars were won with the declaration, and all wars ended with the declaration. And that's what we're after, declarations of law to protect ourselves. That's where your armor is right now. Your armor is not in Parliament. You need the arms of the law wrapped around you with a declaration to protect yourself from this confusing weaponization of law that's being used against you. It's called a weaponization of law or a waterboarding of law, and you need to arm yourselves with the law against it, because a gun will beat a gun, a knife will beat a knife, and law beats law. And that's what we're after in the Ministry of Deconfusion, is to show you the way that you can use your supreme law to beat their subordinate laws. And so that's what we're doing. Law fights law, gun fights gun, knife fights knife. And we want the arms of the law by declaration. Now, I'm going to show you just quickly today. I've only got a few minutes because many people messaging me. Everybody's asking me for help. I can't help you all. Oh, my goodness. You've just got to follow and figure out how to do it. So this is called So I think I can enlarge this to about there. Right, so this is called the Cabinet Manual, okay? So I'll put that up there. Right, now I can see it moving. All right, so this is called the Cabinet Manual. And each of our countries, England, Scotland, Ireland, has got one of these cabinet manuals. And this, when they enter the Parliament, this tells them all what they have to follow. So I'll just go to the top there. So this is the cabinet manual for Wellington, New Zealand, but there are other cabinet, each country's got their own. And you'll see that it's got the strike under here, New Zealand government. So this is the New Zealand, and this is the supreme law. When they enter Parliament, these are the laws that they have to follow. This is what the Sovereign Governor General has to follow. This is what the Ministers of the Crown have to follow. This is what the Ministers of the Law and Inquiries, all cabinet decision making must be based on this. All elections, transitions, government formations must be based on this. The executive, the legislation, and the House must be based on this. Official information and public records must be based on this. So it all comes under here, and it's all patented and it's all constituted. I don't know why they're going around lying to you, saying that we don't have a constitution. Your constitution is right here in the Cabinet Manual. This has all been constituted. And then there's a whole bunch of stuff there. But if you go down here, it will tell you some. You can go and study it if you want to. But if you've gone down here, it's going to tell you about the constitutional law that they have to follow when they make laws. And whenever they haven't followed it, then they need to go and correct it. And this is your arm of the law. This is where you use these arms to go against them when they're using the arms of subordinate laws against you. You use your arms of constitutional law to go against them, okay? Because steel sharpens steel, doesn't it? And law sharpens law. That's how it all goes. So it's no good fighting them with whatever you're doing. Law fights law, right? So it's saying here that this is what they recognize. The 1986 Constitution Act, well, and then this removed the 1852 Constitution, and it brought in the 1993 electoral law. And this only just, this only constitutes Parliament and gives them the right to be in Parliament. And it constitutes them to be allowed to levy taxes, get loans, to spend public money, and except by or under an act of Parliament. So that means that they need an act of Parliament in order to get your taxes, in order to get loans, in order to spend your public money. They need an act of Parliament. But in order to make those acts of Parliament, right, what do they have to follow? They have to follow all of these laws here. And where do they derive their power from? It's derived from the Queen. Where does the Queen derive her power from? It's derived from us through the 1688 Bill of Rights. So you can see here that the laws that they have to follow when making their subordinate laws are the State Sector Act 1988, the Electoral Act 1993, the Senior Courts Act, the District Court Act, and the that relate to the three branches of government, the Ombudsman Act, the Official Information Act, the Public Finance Act, and now here you see it right here, folks, the 1989 New Zealand Bill of Rights Act. Now what you'll see here, that all of these are acts. But then they'll go to the English law, where all of these acts derive their power from the English and United Kingdom. So here's your United Kingdom Cabinet Manual right here. So this applies to Scotland, Ireland, but use of each in your own right got one of these, but I don't have time for them today. So I will. So what you'll see here is that in ours, they followed the Magna Carta of 1297. Now there's a Magna Carta of 1215, but that is followed by Scotland and not followed by us. But there's a bit of controversy because this Magna Carta was only introduced in New Zealand in the year 2000. It's not even supposed to be in our law, but that's a whole nother story. But you'll see here the Bill of Rights 1688, and you'll see here that it's not an act. That's the difference. This New Zealand Bill of Rights is an act, and it can be overridden by this Bill of Rights, which is not an act. It is a constitutional law, and it's the highest law of Almighty God. Then you've got the Act of Settlement 1700 to do with the succession of the throne and other matters, and that also is not an act, and that derives its power from the 1688, and all confirmed as part of law of New Zealand by the Imperial Laws Application Act. And the important thing to remember here is that it's only the application of the 1688. It's not the 1688 in itself. It is only the application of that act. And if anything in the application violates the actual 1688 Bill of Rights, then that can be struck down. So it's power, the power of all of these, and the power of the Act of Settlement, the power of the laws of application are all derived by this Bill of Rights 1688. And all of these acts derive their power from here. And so that comes under the powers of the Queen, right? So then you've got your Treaty of Waitangi. This is personal to our New Zealand native people, and you'll have treaties in Scotland and treaties in Ireland, treaties in Australia, which are separate, but they all ultimately derive their power from the common law, which is the written common law of 1688. So they all derive their power. And then they use conventions. That was some cockamamie thing that they came up with in the Court of Canada. They came up with the constitutional conventions, where something that is used over and over again becomes a law by convention. But even that can be overridden by the 1688. It is the very toppest of the highest you can go. Now, if you go down here, they go on about all their rubbish, but you don't need to worry about all of that. But it does come down here. You can go and read this yourself, but they're talking about changing the constitution, sovereign of New Zealand and their powers, formal powers. You can go and look at all this yourself. I'm just introducing it today. I can't do everything for you, but it does, the clerk of the executive, the meetings, the preparing, the meetings, quorum and attendance, confidentiality, gazetting and entry, the announcements, the honour system, the administration, nominations, honourable, foreign honours, heraldry, precedents. I was looking for the appointments, the roles. I hope I can find what I want. Resignation, legal power, roles of the ministers, financial responsibility, ministers outside and ministers of state, ministerial portfolios, associate ministers, acting ministers, duty ministers, parliamentary undersecretaries, parliamentary private secretaries, conduct of ministers, registry of pecuniary and specified interests, ministers' interest, identifying conflicts of interest, association, managing conflicts of interest, constituency interest, interactions, I'm going to get to where I want, gifts, cultural gifts, political party donations, speaking engagements, endorsements. So all provision, advertising, travel, approval, travel costs, reporting, visits, not where I want to get, public service, state ministers. So everything that they have to do, every single one of them is in here. And if you go and check it, it talks about all of their responsibilities to us. And I don't think any one of them have even read it. And I think that they need to go and have a whole new learning about this, monitoring companies, state-owned enterprises, state sector. So this is all processes, hang on, public, trying to get to the place where I want, caucus, communications, the law. This is where I am doing. Now this is talking about the role of the Attorney General. This is where I wanted to get to. This is talking about legal proceedings involving the Crown. And this is when you use your 1688 Bill of Rights and you use your 1908 Declaratory Judgment Acts. That is the only means. So you can go to your 1688 Bill of Rights here, and it tells you here, right on here, and if you go to the frequent, it says this, using this document is the only means for obtaining remedy or redress against parliamentarians that are making laws repugnant to your Protestant right. So your Protestant right is the highest right because it is a right of protection and not a right of violence against anyone. It's a right of protection, and that's why it became the highest law above, it became above canon law, above Islamic law, above Torah law, the Jewish law, because the Protestant law was the only one that had only laws of protection and no laws to provide stoning of people, burning of people, violence against people. The Protestant law was the only one that it was solely a law of protection for us against them. And that's why it's held at the highest levels, even by the Pope. And the only way to get this, the only means for obtaining is to go to the court and ask for a declaration from the judge. Now that means that a law was created within Parliament that was repugnant. And if that law was created repugnantly, then you would institute legal proceedings involving the Crown, which is the Prime Minister and all of them. And then what it says here, I did want to say something important. He gives the advice, functions. It tells the way that the parliamentarians are permitted to speak and what they should avoid to get them, they must avoid to get themselves into trouble. This tells them, and then this is the litigation involving ministers of the judicial review. And the judicial review is the review by the judge in the High Court or for the exercise of or non-exercise of a decision-making power in order to determine whether or not the decision was lawful or valid. Most formal decisions taken by the executive arm of government, including ministers, and the process by which they are reached can be reviewed by the court. Ordinarily, a power that is subject of review proceedings will be one that has been conferred on the decision maker by the statute, which is usually in the 1688. That's why it's so important to you. In the occasion that the courts will review the exercise of public powers in principle, all exercises of public power are reviewable, whether the relevant power is derived from statute, the royal prerogative, or any other source. However, the courts acknowledge that some exercises of public power are not suitable for judicial review because of their subject matter. The courts will most likely unlikely to intervene in decisions about policy formation by the government of the day or involving political or fiscal considerations. You won't be able to take them to the court about money and the policy decisions, but it's only when they've made a law that is repugnant to your subject right. That's when you can take them. And he says that this does not mean, I was looking for, it says here, all right, this is what I wanted to tell you about the ministers. When you call a minister to court, they themselves as an individual are not in any trouble. It says that the ministers can be named as defendants, but often you'll name them as respondents, which I did. But it's almost always in relation to the exercise of their ministerial power, and most proceedings would be by way of judicial review, which will involve a legal challenge to the way in which a particular, usually statutory power has been exercised. And this is what they're saying. In this case, the ministers would not be at risk of judicial review proceedings at all if it were not for their official position. So it is the convention of government, therefore, that ministers should be indemnified by the Crown for any actions taken against them for things done or decisions made in the course of their ministerial duties. So I'm just going to cut off because I'm not going to do this. I'm not really doing this today, but I just wanted to show you that the 1688 is in the Cabinet Manual, and the 1688, my hat's crooked, is the law that they all have to follow. And what I wanted you to go and do and look at that is the judicial review is saying is whenever they've made a subordinate law that's repugnant to your statutory 1688 law, which is the supreme law, you are entitled to go to the court and call the minister to the court about that point of law. You're not allowed to call them to the court about their policies unless their policies presently are being waterboarded upon you and causing you stress and not able to function and think about those laws because they're using too many. So that's a way that they're using the law against you. This has never been prosecuted. Well, it was by Simon Fish. Simon Fish went to the court with an omnibus law because they were using hundreds of laws against the public, and the public was stressed and couldn't cope anymore. So Simon Fish did that 400 years ago, and Kate Floss is going to do it again 400 years later. But I'm just letting you know that when you go to the judicial review, you need to use the only way that you can get your judicial review is by using, you can use that 1990, but it's only an act. It's when you go to the 1688 that you're in the very heart of your power. when you are really unleashing your almighty godly power that each and every one of you owns. And it's your almighty godly power that you need to be using right now. You need to be getting out of the acts, getting out of the subordinate laws, and going directly to the heart of your own godly power, because you are all gods in your own right. You as an individual by yourself are a God. And you are put under Almighty God, which is all individual, one God by one God coming together in the heavenly realm of the Almighty God. And then you become subject of your right that they can't take away from you. So that's how you get into the heavenly realm. You're all not getting in the heavenly realm because you're not using your heavenly godly power that you have. So we got to law sharpens law, steel sharpens steel, law sharpens law, and you have to use a higher law, a bigger sword, or you have to use an equal sword against them. And you're going to the court with your axe, which is a subordinate law against their mighty law of law against you, and that's why you're not winning. So you've got to use godly law against godly law. That's what you've got to use. And then that, when you go there with the prayer. So I'll talk about that later. I've got to go. I'm coming up with a video in a bit. It was supposed to start at 7:30, but obviously it's going to start at 8. So 8 o'clock I'm coming back on, posting up this up now. 8 o'clock I'm going to be coming back on and with a video about the Justice Committee. All right, and we're going to the Justice Committee. Right, stop recording. Kate Floss, Ministry of Deconfusion. Minister, I am a minister in the Ministry of Deconfusion. And this is, we're going to learn about our laws and the arms of laws that are going to be protecting us from these evil deities.